Okay, everyone, so this is what I learned in week 1 of Constitution. These are some of the topics that we're going to be going through: conquest versus settlement, Campbell versus Hall, Thomas Carlton, date of reception, transition between 1785 and 1864, the factors leading to Federation, the Charlottetown Conference, Quebec Resolution, London Resolution, and of course the Constitution. So this is the story of how my ancestors, I guess if you're white, or your ancestors as well from England, came to Canada, took power, and that power, of course, was invested in the monarch, which is kind of an autocratic feudal system that eventually gave way to the principle of democracy through much effort from the citizens of the colonies, and also because it was really expensive to run an empire. So this is the story of the rise of democracy in Canada. But of course, we start with conquest and settlement. So the imperial powers in England went around the world and settled and took land by conquest. Now, sometimes when they took it by conquest, they arrived with a small force, and in order to let things kind of work themselves out locally and not upset too many people, because they might not have very many people to, stop an uprising, they would allow local private matters to be resolved by the local law, and they would enforce public law. Now, sometimes they would arrive and they would take over the area by settlement. In other words, they would follow the principle of terra nullius, which means that they considered there to be no one of any worth or that could be considered a person in there, and so the English people would arrive with all the rights and protections, civil and public, that they have through English law. Now, so they would arrive, they would establish colonies, and which brings us to 1774, Campbell Hall. This is a decision in a case dealing with the validity of tax imposed in Grenada. Now, this is a decision from the King's Bench in England, and ultimately what was decided was that the monarchy has absolute authority in the colonies until a representative assembly is granted. So that's important as we're moving forward, so that's the Queen establishing and declaring her authority, through judicial decision until some form of representative democracy starts to form in the colonies. So in 1784, Thomas Carlton was commissioned to be the governor of New Brunswick. He was the first lieutenant governor, and in his commission from the monarchy, who of course had absolute authority, he was given the power to organize a legislative assembly. He was given the power to enact laws for the public peace, welfare, and good government, which is very nice of the imperial powers. Of course, they were looking out for their own well-being, but nevertheless, we can see some of the underlying principles of humanity here, I suppose. The power of disallowance, to disallow laws that are created by the Legislative Assembly, the power to organize defense, and the power to control public money. So ultimately, almost unlimited powers granted to Thomas Carlton. But one of his important roles, of course, was to create the Legislative Assembly so that the colony could start making their own laws and having some authority over or more authority over their business. And that led to the elections only 1 year later in 1785, and in 1786 was the first session of the New Brunswick Legislative Assembly. So this brings us to the date of reception. This is an important principle when we're looking at the rise of local power and the principle of democracy. The date of reception is when a colonial jurisdiction receives a book of common law and statutes from England, and all of those statutes and common laws apply where they're applicable. If there's a statute about the bridge over River Thames, that's obviously not applicable. And it's also important because New English law does not automatically apply to this jurisdiction. Now, generally, whenever a jurisdiction would form a legislative assembly, they would assume that as their date of reception, and they would start creating their own laws. But they do have the choice to choose a date of reception, and New Brunswick chose 1660. due to the fact that they didn't want to update their election laws, or the dominant powers didn't want to update their election laws. And this is a date that's commonly chosen throughout the colonies, including Virginia, and is the date of the restoration of the Stuart monarchy. So, we've got a legislative assembly, we've got a date of reception, and now it receives a period of friction between 1785 and 1864, and this is between the principal democracy and the imperial powers. So the local interests trying to govern their own affairs, and the imperial powers still holding some authority and dominance over the local affairs. So we see a transition from representative to responsible government. So some people were allowed to vote. If you were a male property owner, then you, of a certain age, you were allowed to vote. However, the governor still had the power to appoint executives, people that we would now know as provincial cabinet ministers. He could appoint his friends, he could appoint people loyal to the monarchy, whoever he wanted. And of course, appointing judges. And he also had the power of disallowance, so any laws that the Legislative Assembly passed that the Lieutenant Governor didn't like, well, he could disallow them. And so, but that didn't go over well with the interests in the colony, and so they campaigned against it continuously. And what we see is that eventually executives need to be members of the Legislative Assembly, in other words, elected, which is what we have now. And judges would be appointed by committee. And we also saw the dissolution of the powers of disallowance in the sense that the Lieutenant Governor gradually stopped using those powers to the point now where, for example, the Governor General in Canada doesn't even have to show up to Parliament to provide royal assent. He can just sign it in his office, or she can sign it in her office, and the bill becomes an act whenever it is announced. So this is a period of transition leading to the 1860s, and right before Confederation. There are a number of factors leading to Confederation, which is, of course, the creation of the Dominion of Canada and ultimate authority over that Dominion, kind of. Anyway, there were a number of internal factors leading to the Confederation, including Montreal business interests, which wanted to expand the railway to the east, especially to Halifax, which was seen as a center of trade. All of the goods from the interior of Canada would be moved back to the mother country through Halifax, and other goods coming the other way. And Toronto business interests wanted to expand the railway west and north. There was also internal deadlock in the province of Canada at the time, where what we would know as Ontario and Quebec were one province, and they had equal number of seats in their colonial legislature, and so they couldn't make any decisions. They were in political deadlock. Now, they needed to make decisions because, well, there was external threats from the U.S. The U.S. Civil War was just ending. There were lots of people with guns, large armies, and they knew how to fight, and could go west, could go north, who knows. Also, the Fenians, which were Irish Republicans who were considering taking over a colony in order to use it as ransom for the independence of Ireland. They also had a reversal of the British policy, which before that was against union of the colonies in British North America. But it was becoming increasingly expensive to defend those colonies, and so they reversed that policy. We also see the end of reciprocal trade, which I'm not sure what that is. So we had the Charlottetown Conference. Initially, this was just between PEI and New Brunswick and Nova Scotia in order to form a maritime union, but as mentioned before, the province of Canada was in deadlock, and they asked to be invited, so they all gathered in Charlottetown and drank and partied and slept on ship because all the hotels were full because there was a circus in town. So it was basically just a chance to get to know each other and talk about some of the very kind of core, basic, fundamental ideas that were going to form part of Constitution. They met a few months later in Quebec and in October and made the Quebec Resolution. So that's 72 resolutions which would form the basis of the Canadian Constitution. Much of this document made its way into the Constitution. There are slight differences, of course, but this is the basis of the Constitution. And there are a number of points worth noting. Number one, federalism. So federalism means that there is a division of power. There is a national power and a provincial power, or provincial powers. And those powers are divided. That is one type of national government. There are others. And what they decided was that the common interests of the people would be the power of the national government, and local interests would be under the jurisdiction of the provincial governments. In Section 3, they noted that the Constitution would be modeled on the British Constitution. In Section 4, it was noted that the executive authority shall be vested in the sovereign of the United Kingdom and administered according to the well-understood principles of the British Constitution. So we see a very direct connection to the mother country. Section 5, there are two parts of Parliament. Section 6, there are two parts of Parliament. A divided Parliament, there will be a Legislative Council and a House of Commons. They go on to describe the Legislative Council, which eventually was the Senate. The members are appointed, and there are limits on the members of the Legislative Council. They must be 30 years old, property owners, and have at least $4,000 above and beyond all the debt they have. And this Legislative Council will be organized by regions. So there are 24 members for each region: Upper Canada being a region, Lower Canada being a region, and the Maritimes being another region. Section 17 describes the House of Commons, and that will be organized by population. It's worth noting that Lower Canada was guaranteed at least 65 seats in the House of Commons. So Section 29, we have federal powers described in more detail. So how exactly are the powers going to be divided between the federal government and the provincial government, which were very important decisions that have had great consequence for the development of Canada. So first, federal powers, they control duties which at the time was the largest source of revenue. They control criminal law, which they kind of learned from the states, where state governments can control a lot of criminal law. They believed that in the relation with the public, the state-public relation, all matters concerning crime should be, governed by the federal government. And they also believed that some of the underlying and fundamental principles of the society was reflected in criminal law, and thus it should be federal. Patents and copyrights, immigration and agriculture, that was shared. And there are also a number of sort of logistical areas that they were in charge of, so banks, ferries, postal service, railways. And it was worth noticing that they had the power to render uniform the property and civil rights of the provinces, though this has been very controversial, and more on that later. So provincial powers, they have the power of direct taxation. So this is taxation directly to or through the citizens, as opposed to through things they purchase, or other indirect forms of taxation. Power of education, seacoast and inland ferries, the management of prisons, and the administration of justice. And they also importantly had control over property and civil rights. So it was determined that property rights, civil rights, the administration of justice in relation to property and civil rights was a local concern. And this was a very important power given to the provinces in order to respect the minority rights of the provinces. So for example, perhaps a large majority in the federal context all lived within a certain provincial jurisdiction, and thus they would have control over their property and civil rights. It was also an important power that the provinces wanted in order to participate in the Union. So other important sections, the Parliament, that's misspelled, the laws of Parliament are that are made supersede the local legislature. And Section 21, there we still see the power of disallowance by Her Majesty, though rarely ever used. So the London Resolution followed, and that was in 1865. And this was the final negotiations for the terms of the Union. And it was only 6 months before the Royal Assent to the British North American Act and the creation of the Dominion of Canada. So we've got the province of Canada, New Brunswick and Nova Scotia. Prince Edward Island is gone. They were unhappy that they were getting less in the deal than New Brunswick and Nova Scotia. And it's worth noticing the changes in number of seats in the House of Commons due to the departure of Prince Edward Island, perhaps other factors, but Ontario's percentage raised from 42 to 45% of the seats, and Quebec's percentage raised from 33 to 35%. So finally, we have the Constitution Act of 1867, that is the modern name at the time. It was the British North America Act. And there are a few points worth noting in here, though most of the points are the points that I mentioned regarding the Quebec Resolution are also part of the Constitution Act. So in the preamble, it notes that the Constitution Act is to promote the interests of the British Empire, and of course it is the British Empire's granting the powers of the Union to these colonies, so they must have an interest in it. Section 9, the executive government and authority of and over Canada is hereby declared to continue to be vested in the Queen, so she still has the power. Section 11 is the creation of a Privy Council, and it's worth noting that all members of the Privy Council are all past and current federal cabinet ministers, plus current provincial cabinet ministers, and possibly the leaders of the opposition, and of course the Prime Minister. Section 17, it's worth noting that Parliament is considered the Queen, an upper house style Senate, and the House of Commons. So there are 3 parts to Parliament. Section 53, bills for appropriating public revenue shall originate in the House of Commons. Section 56, the powers of disallowance. So within 2 years after receipt, if the state feels like it, they may disallow the act. And that's the Queen. Section 6971 was the creation of Ontario and Quebec out of the province of Canada. Section 94, again, the uniformity of property and civil rights. So it's the federal government powers to make uniform the property and civil rights of the provinces, which is has been determined through the years by the judiciary to be too autocratic. That the federal government would have too much centralized power if it were able to do that, though I'm a little foggy on that point. And lastly, section 101, Parliament can establish courts, but they cannot abolish the Supreme Court of Canada as it is inherent in a federal state. So in summary, this is a story of the creation of Canada, which you may have noted has no mention of First Nations anywhere. So this is the story of the European people coming to Canada and installing the authority of the monarchy and bringing over colonists, and the rise of the principle of democracy, the creation of the principle of federalism through the Constitution, and eventually the creation of the country of Canada. And that's what I learned week 1 in Constitution class.